Good afternoon, everyone, and welcome to the latest In Touch Credit Union webinar series. My name is Josh, your host for today's seminar. Well, co-host, really. I've got another two lovely gentlemen on with me today. Today's webinar is from our preferred partner, Trust and Will. We have O'Neill, who will be our guide through everything. He will be presenting today, and this is a program available to all In Touch Credit Union members. But that's all I'll say because I want him to take it all since he is the expert. But this webinar is being recorded, so if you have to step away or you miss something or you want to share it, this will be available later on our YouTube channel, ITCU Inspire. If you have any questions, please feel free to put them in the Q&A box. We will be answering those at the end, but we will take your questions. And without further ado, I will hand it over to our host with the most, O'Neill.
All right. Thank you, Josh, and welcome In Touch Credit Union members to today's Estate Planning 101 webinar. I will be your host today, and my name is O'Neill. Yes, believe it or not, my first name is O'Neill. I manage all of our credit union partnerships here at Trust and Will, and I am joined today by Jason Young from our member support team, who is manning the chat box to your right of your screen here. So if you have any questions at any point in time, please feel free to, at any point, jump into the chat to ask any of those questions, and Jason will respond to you in the order they come in. So speaking of the chat, within it, you will find a link to Trust and Will's website, which is hosted on the ITCU website. So if you click that link, you will receive a special discount code thanks to our partnership with your credit union. So as we get started here, feel free to click around on the website to see a little bit more about what we do and how we can help you. Today, we'll be discussing the basics of estate planning. So we'll start by defining why an estate plan matters and what an estate plan is and does. Then we'll cover some of the key documents in an estate plan and how to decide which documents are best for you. And finally, we'll conclude with who needs an estate plan, some of the most common reasons it might be time to create or update your plan, and how you might get started to doing so. Once again, if you have any questions, please pop them right into the chat and we will answer as they come through. But to set the stage for the gravity of this topic, it's important to know that estate planning is the largest personal transaction of your life. That said, it's typically also the piece of financial well-being that is least prepared for by families. Without a plan, most people end up leaving their assets and legacies subject to probate, which means the government makes all decisions on your behalf. Unfortunately, nearly 2/3 of American adults procrastinate on their estate plan until it's too late. And the three primary reasons for this are: one, a lack of education around the risks of not having a plan, something that we're hoping to tackle today in this presentation. Two, the cost. You can typically expect to pay thousands of dollars to draft estate plan documents with a traditional local attorney. And three, the inaccessibility that comes when you're not really sure who to turn to do things right. So ITCU has partnered with Trust and Will to help you through these hurdles with our modern and affordable estate plan technology. But first, let's start with what is estate planning. Estate planning is planning today for what happens tomorrow. At the most basic level, an estate plan lets you make decisions today about what should happen if you are unable to make decisions in the future. It is a set of instructions in which you can specify what you want to happen to your assets, your belongings, and your physical body. So why should someone care about estate planning? What should motivate someone to create an estate plan? There are many reasons to care. First and foremost, peace of mind. You'll feel confident knowing that you've taken the necessary steps to protect yourself and your loved ones, and you can rest easy at night knowing that you've made a plan and you've put one in place for what should happen if anything ever goes wrong. Having a plan also avoids leaving your loved ones with no guidance during a really difficult time of grieving. The peace of mind is truly priceless. Another major reason is to prioritize, Another reason to prioritize your estate planning is so that you can name legal guardians to care for your minor children, and your pets. Knowing that your children and pets will be safe and in the right hands if the worst should happen will also bring peace of mind. And the third reason estate planning is important is so that you can prepare for potential incapacity during your lifetime. That's right, estate planning isn't just after you pass away. In fact, studies show that the majority of Americans will be impacted by incapacity in some way or another, via themselves or their loved ones during their lifetime. And so having a plan in place can be critical to ensuring your desired outcome. It can also make things easier for your family to respect your wishes. This is something that's often overlooked, the importance of incapacity planning. But then when someone goes through the process, they'll realize it winds up being one of the most important factors because it happens during your life. So these are all very personal decisions. There's no easy way to have a default rule that matches your desires, and there's no certainty that anyone else would make the same decisions that you might for yourself. So when it comes to estate planning, there are several things to think about, including asset distribution and business succession planning. So on asset distribution, this is a primary motivation for many people. It's the ability to control where your assets will go after your death. And you can choose to have your assets benefit family and loved ones. You can choose to support charities or organizations and causes that are meaningful to you, or you can use this to minimize taxes and to maximize the benefit for your beneficiaries. Many people equate estate planning with asset distribution and only that, and that certainly plays a large part, but it is not the end all of estate planning. There's succession planning, end-of-life planning, incapacity planning, all of which relate to healthcare documents, which we'll get into a little bit later on as well. Another piece is business succession planning, which is often overlooked by individuals who own their own business. This can be critical to ensuring the business does not evaporate upon your death, and the absence of a plan can lead to heavy loss in valuation, which can really impact and significantly decrease the inheritance left to your beneficiaries. So we've got the why down, but what is an estate plan? An estate plan is a set of documents containing instructions for what should happen if you cannot speak for yourself, whether you're incapacitated or have died. An estate plan is typically multiple documents, not just one. The documents in a plan will vary person to person, but should be tailored to meet your needs. Each type of document is designed to do one thing. Your plan might focus on just one or two of these things, in which case you would only have one or two documents, or your plan might be more comprehensive with a full suite of documents. But typically, you will have wills, trusts, and healthcare documents. Let's dive into each of those separately. What is a will? Your last will and testament is legal documents that control most assets when you die. It goes into effect after your death. So what's its purpose? A will handles fundamental needs for everyone. Therefore, if you are at least 18 years old, a will benefit you. There are three primary functions of a will. First, to determine who will receive your assets when you die. Second, to nominate guardians for your children and pets. And third, to specify your final arrangements. Do you want a traditional funeral or a memorial? Do you want to be buried or cremated, etc.? So what's the logical next question most people have? What happens if you don't have a will? The functions of a will are essential. These matter. It's who will get your things and distribute your assets, and they have to be addressed even if you don't have a will. So what happens is state laws will fill in the gaps to make decisions for you. This is one of the most common misunderstandings. Many people assume that these default laws will give the same result as you might want for yourself, but that really is not always the case. Here's an example. You're married with 2 kids. Depending on where you live, state law may provide that your assets are divided 1/3 to each family member. You may not want your kids to get 1/3 of all of your assets right when you die. Your spouse might not be able to maintain a house or the standard of living with only 1/3 of assets themselves. So depending on your state's laws, this is something that could happen if you die intestate. However, with a legally binding will in place, the court will likely honor your wishes as stated. Let's focus a little bit more on how a will works after death. Wills go through probate, a judicial process to determine the validity of a will and to appoint an executor. If you don't have a will, the court will appoint an administrator to perform the same functions as an executor, which is usually a relative. But if you have no will, it may not be a person of your choice. The executor, once appointed, is the manager of the probate process, and their job is to collect assets, to pay debts, expenses, and taxes associated with the estate, and to distribute assets to beneficiaries. But probate is often undesirable because, one, it's slow. It can take 12 to 18 months, and that's pre-COVID. Sometimes you can expect over 2 years within some courts and within some state courts. Two, it's difficult and it's stressful. The process begins immediately after death during a period of grieving and loss for your loved ones. So this often brings out resentment and can lead to disputes. And three, it's expensive. In California specifically, $1 million estate can cost $50,000 in statutory fees for probate. And that $1 million includes the house and its gross value, not equity that's been accumulated. So probate avoidance is a huge motivator for some, and it is one of the primary reasons why many people look to set up a trust. So what is a trust? A trust is a legal agreement between three parties. There is the settlor, the trustor, the guarantor, the grantor, who creates trust and puts their property into it. There is the trustee, who holds and manages the assets in the trust. And then there's the beneficiary, who the trust is in favor of. So basically, the settlor creates a trust and gives the assets to the trustee to hold for the beneficiary. There are 5 primary purposes of a trust. A trust can help to avoid probate and all of its negative consequences. A trust helps to manage and distribute assets, giving you a little bit more control over when and how assets are distributed. You can insert contingencies within your trust. A trust applies both during lifetime and after death. This means a trust can be useful in planning for incapacity and can ensure that there is seamless transition of control. And fourth is to provide for your family. This is a big motivator for many people with younger children or blended families. Trusts give more control over assets that will eventually benefit your younger children. They also give control over providing for your spouse for his or her lifetime, but then ensuring those assets pass to your children after your spouse's death. And fifth is to minimize taxes. So what is the role of a trustee? A trustee is like the CEO of a trust. You're bound by law in terms of trust, but it is still a critical role in executing the duties. A trustee can work with other professionals and advisors. When choosing a trustee, you'll want to select someone that you trust, but also someone with the ability to carry out these duties. So popular choices are a spouse, a child, or your children, relatives, close friends. And there are 4 buckets when considering types of trusts. There are revocable living trusts, which are the most commonly used type of trust. When most people think of a trust, they're thinking about a revocable living trust. These are created while living. They can be changed or revoked, and the assets within will avoid probate. Second, there's a testamentary trust. These are less commonly used, but they're created under a will. A testamentary trust is only effective at death, and these can be easier to create, but typically do require probate. Depending on the complexity of your state, there are also other types of trusts, including trusts used for tax planning. Examples of those would be credit shelter trusts, Q-tip marital trusts, irrevocable life insurance trusts. And then there are also trusts used for other purposes, such as special needs trusts, asset protection trusts, and Medicaid planning trusts. Trusts and wills have similarities, but also differences. Each do things that the other does not. The similarity lies in the fact that both documents dispose of assets. Some differences are that trusts avoid probate, wills go through probate. Trusts give greater control over when and how assets are distributed. Wills can be easier to set up. Trusts can sometimes take a little more work. Trusts apply during lifetime, and wills nominate guardians and specify final arrangements. So trusts are usually paired with a will as a set. So when should you consider a trust? One reason would be if you have younger children. Rather than having all of your assets go to your kids immediately or when they turn 18, a trust can help you set triggers for asset distributions. Some of those triggers could be when your child hits a certain age, or a life event, graduation, getting married, and that helps to stretch out distributions as well over time. Another reason to consider a trust would be if you have complex family dynamics, blended families, second or third marriages. Trusts can let you benefit your spouse for their lifetime, but then ensure your assets go to your kids, not to a second marriage or a stepkid. Another reason is privacy. Wills become public through probate, but trusts stay private. And the final reason is if you have higher asset levels. Trusts can help to avoid probate, which in some states kicks in after 100,000 plus in assets. And trusts can help to minimize estate and income taxes. The federal estate tax kicks in at $12.9 million today, but that could be lower based on the administration in office and is subject to changing at any point. So trusts also provide the opportunity for more advanced planning and can help you stretch retirement distributions. If you have retirement savings that you plan to leave to your beneficiaries, a trust may provide a tax advantage way to distribute those retirement savings over time. So we've covered wills and trusts. Let's talk about the third piece of things, which are healthcare documents. And healthcare documents, there are three types: a power of attorney, healthcare directive, and HIPAA authorization. These three documents cover what happens when you are incapacitated. While a will or a trust covers what happens to your property when you die, this part of your plan helps to cover your wishes for your finances and care while you are still alive. Your power of attorney, or POA, designates someone to make a non-medical decisions for you: financial decisions, business decisions, handling of any day-to-day transactions, bills, etc. Your healthcare directive, or living will, as it's also known, specifies your medical preferences in advance and designates someone to make other medical decisions for you when you're not able to voice them. Your HIPAA authorization ensures that designated agents and representatives can speak with your medical providers. They can make decisions, consider costs of treatment, and also ensures that stakeholders in your care have access to your private health information and can communicate with care providers about your medical history and decisions. And this piece is often overlooked. So who needs an estate plan? All adults at the end of the day need an estate plan. Common reasons to create one, those triggering events are marriage or divorce, having a child, a grandchild, or adopting a pet, accumulating assets, medical concerns, dealing with another death of a friend or a loved one, or approaching retirement. These are all events that sort of reinforce that need and push it towards the top of your to-do list. That said, your plan should evolve as your life does. So you'll want to make sure that your wishes are properly reflected as your life changes. When your needs change, you'll want to consider updating beneficiaries, changing guardians. As your kids get older, they may need a different guardian. And generally speaking, you'll likely have different preferences for your plan as you age. Some of the more common triggers to update your estate plan include major life events like births, deaths, changes in marital status, retirement, and the passage of time. It's worth revisiting every few years as your life evolves. And As children become adults, they'll need their own plans. While your child is under 18, you have parental rights, but once they turn 18, they'll need to have their own legal documents in place to let you act on their behalf. Once you've chosen your plan, you'll only need a few things to get started. I promise it's not quite as intimidating as you may think. You'll need basic information like you, your spouse, and your kids' full legal names and birthdays, an idea of who you would like to act as guardian for your children and who you might appoint as executor or trustee, and how you want your assets distributed, what percentages, and to who. You can include specific assets like jewelry, your car, cryptocurrencies, or state that you simply want a portion of everything left in your estate to go to specific individuals. Lastly, you'll need the names of financial institutions where you hold accounts, as well as addresses to any real estate that you own, and if applicable, names to any businesses you own. But at the end of the day, that's it. What you won't need is Social Security numbers, bank account numbers, online passwords, real estate titles, or any relevant business ownership paperwork. Like I said, it's really not as complicated or as scary as most people assume. And if you're not ready to get started, but perhaps you want to poke around and learn a little bit more about estate planning, our website, trustandwill.com, has hundreds of articles on the topics of estate planning, everything from what happens to your airline miles if you were to pass away to more basic questions about the differences between wills and trusts. You'll also have access to our member support team to ask any questions you have. And on that note, it's time to quickly chat with you about how we can help you check this off your to-do list in 30 minutes right now or tonight or over your lunch break later this week. Trust and Will is the TurboTax of estate planning and the highest rated digital estate planning platform in the country. We've helped nearly 500,000 families complete their plans by removing the typical barriers to getting this done. We make estate planning affordable, accessible, and easy to accomplish from home. On average, you're going to save over 70% versus what you might spend working with a local attorney. That said, we also have a network of local attorneys ourselves. So if you would like to speak to an attorney or to have them look over your documents once you create them, you can select to do so for an additional fee. Today, we offer two major packages that are comprehensive and state specific. Our will package includes your last will and testament, as well as your healthcare documents, your power of attorney, healthcare directive, HIPAA authorization. And again, these are all state-specific documents. They are designed by our team of attorneys and customized to your needs. And we also have a trust-based package, which includes everything in that will package, as well as your revocable living trust. With ITCU, you'll also get a special discount, 10% discount off of any purchase that you make because of the partnership. That said, as a quick sneak peek, we will be increasing that discount in April only through the lens of Financial Literacy Month. So if you do make a purchase in April, you'll get an added discount as well. But to learn a little bit more about how this works, if you're unsure still of whether a will or trust might be a better fit for you, you can go to our website and click on the link to take a quick quiz, which will help to suggest a will or a trust, whether either might be better for you based on your personal circumstances. And then from there, you'll dive into one question at a time. It's very simple and intuitive, and you can answer those questions, save your progress, come back to it later. On every page, you'll have a chat bubble with access to our member support team that can answer any questions. And that team, like Jason here on the call today, they're available 6 days a week to answer any question that you might have. These are real people. They are employed by our team. They are US based, and they can answer 99% of questions for you or help guide you to resources and articles, videos that can provide you with education to make the decision for yourself. And our member support team, at the end of the day, they're the reason we are so highly rated and preferred by members and their families. So how do you get started? Again, pop into your chat bubble and you can click a link to ITCU. If you search for estate planning within the InTouch Credit Union website, you will find a link to our page. Within that page, you can click that Get Started link, and that will redirect you to our website with that special discount automatically applied at checkout. And on our website, you'll have a wealth of other information to help you make decisions and to inform you about other questions you might have on estate planning. So that is our topic today. I hope that you felt informed and learned something in our Estate Planning 101 webinar. I really appreciate your time, and we're really excited about our partnership with ITCU to help you with the largest financial transaction of your life, to prepare for the future, to have that peace of mind, and to finally check this off your to-do list if it has been lingering for a while. So with that, I will pass it back to Josh and open it up to any additional questions that may come through.
Thank you, O'Neill, and Jason, thank you. Jason is answering questions in the Q&A along with myself. I'm only handling the InTouch related questions. Jason is the expert, as well as O'Neill and Trustin Wills, so I appreciate having both of them here. One question I get a lot from members, though, and O'Neill and Jason, feel free to chime in on this as well. As a financial counselor for the credit union, a lot of people come and ask me about, is adding a beneficiary to my account just enough? And usually the answer I tell them is, it's a great start. However, institutions will follow the letter of the law when it comes to beneficiaries. So if you do have specific wishes that you want carried out, it's better to do more than just the beneficiaries. And O'Neill, I think you said it before, there's other things that can come into play, like probate and challenges and all this kind of stuff. But with a will or an estate, there's a dedicated plan. It's handled by an expert legal team to help avoid those situations. So would that be a take that you would say as well? I mean, adding a beneficiary is a great start, but let's look at doing more just to make sure your wishes are carried out the way you want.
Right. There are select accounts, and like with your life insurance policy, for example, if you have an added beneficiary, that can sometimes avoid probate. But there are a number of other assets and accounts that will wind up going through probate, even if you have nominated beneficiaries in some instances. And so it is important for you to have these documents in place so that your wishes are carried out and your legacy lives on.
Awesome. Always makes me feel better knowing I'm giving our members the best information possible. We have seen some questions. Some of you on here have said that you are not current members of InTouch Credit Union, and that is perfectly fine. These webinars are for everybody in our communities or who may have a friend or family member who are members. So you are free to attend these webinars. If you would like to join or take advantage of these programs that we offer, please feel free to reach out to us directly at www.itcu.org, or you can reach our contact center financial assistance at 800-337-3328. That was one other question that we had. And it looks like Jason has knocked out the remaining questions to everyone, which is great. So we still have a little bit of time left, which is awesome. But if you guys still have some more questions, feel free to pop them in. Just remember, Trust and Will is a preferred partner of InTouch Credit Union. All services provided are through them. While we are happy to direct you to them or maybe answer some basic questions here at the credit union, we do highly recommend anything regarding trust, will services, or services they provide, you'd contact them directly. I do know that sometimes our bankers and tellers will get asked questions about trust and will, and would love to answer, but they will direct everyone here back to trust and will or to a legal expert. As much as we may want to help, we want to ensure we are giving all of you the most accurate information possible. Oh, some more questions. Oh, and O'Neill, so for trusts, um, this was actually something that happened recently. So a person wanted to add a beneficiary as a trust. Can you speak to that at all, or what the benefit of that would be? So instead of adding, say, my niece as a beneficiary to my account, I added a trust as a beneficiary.
Jason should be able to address that directly. I don't want to mislead anyone in that topic.
Yeah, so you can put the trust as a beneficiary on an account. I mean, a lot of times that'll save the extra footwork of having to actually transfer the account itself into the trust. So you could just list the trust as like a beneficiary on a bank account or something like that. And it just kind of takes a couple of steps out of the process, as that's generally easier to do than filling out all the paperwork to put the account in the trust. And all financial institutions have different methods for actually transferring the account into the trust. So yeah, a lot of folks just put the trust as a beneficiary and it essentially accomplishes the same thing.
Thank you, Jason. And at InTouch Credit Union, yes, we do allow for trust and estate accounts here. We have opened several over our almost 50 years of existence. So you can stop by our branch, contact our call center, or schedule an appointment today to learn more about those types of accounts from our bankers. There is a specific question, Jason O'Neill. Members are asking if they can get a copy of this deck. And members, I want to let you know that this is being recorded, so it will be available on YouTube later for you to review. Um, as far as the deck,
I can
up
share
to
a copy with you, Josh, after
yeah,
the call, and you can distribute it, as well as potentially sharing that link for anyone afterwards, so that they can sign up and register. Again, it's free to register for an account. Eventually, you'll hit a paywall to make a purchase, but to sign up, you can register for free and learn a little bit more, and begin, clicking away and chipping away at your estate plan.
awesome. There was a question about sharing the questions. Unfortunately, we don't share all questions because some of these are asked to be some of these questions are asked to be shared privately and are answered privately or answered anonymously. So for privacy reasons, we won't share questions um, directly. There are some I can read off, but again, a lot of these questions we're getting for this specific webinar are very situational specific, so they would not apply to everyone here. And because this is such a heavy topic and a very important topic, it's best if you would reach out to Trust and Will directly with any direct questions. Again, we want to make sure that your specific questions and situations are being answered, instead of giving you a trying to make it a one size fits all there. And we're still getting some questions, and Jason is uh, getting to those as we go. And then for anybody on this call, um, in my age bracket, which I am a millennial, Gen Y, this is something that we talk about often, especially in a lot of my YP groups. And when I talk to the generation below me too, they're even talking about it. So the good news is this topic of trust, wills, and estates is being talked about, which makes my heart happy as a financial educator, because not to be morbid, but anything could happen, and we want to make sure that our families and loved ones are protected. And this is something that my sister and I went through ourselves because she has two kids, and I am the responsibility of those two children. If anything should happen to her, knock on wood, nothing does. But also after going through this with parents, and I'm loving to see, O'Neill and Jason would probably be just as happy too to see that this is becoming a more and more common subject to talk about, and it's not just viewed as this is something I need to do when I'm older. We need to start addressing it as soon as we can, just to make sure.
Absolutely, Josh. And I think having things digitally makes it very easy to update those documents. So rather than having to go back to an attorney and repay them to update, small changes within your estate plan, you can click back to your digital estate plan, make a few changes, reprint your documents, go notarize them at your credit union branch, and check that off your list. So we're making things easier.
And O'Neill and Jason, we at InTouch Credit Union, even though we're physically located in 3 states, we do have members in all 50 states, all U.S. territories. Trust and Will would be able to help all of them. And then I have a caveat question after you answer that one.
Yes, we are available in all 50 states and can help you to create state-specific documents in each of those states. So, and then notarizing your documents, you can typically do at a FedEx or UPS or a bank location.
And some places, even libraries, chambers of commerce, will do this for you too. Members on the call, if you go to a financial institution, call and ask first if you're notarizing any legal or trust documents, just because some institutions do and some don't. So be sure you call ahead, because again, you don't want to make the trip only to be told, hey, we can't notarize those. I do know most of our members do get their notaries done at for these types of documents at an attorney's office. So will we get a new link in April for the increased discount? Yes, we will be sending an email out to members for the Financial Literacy Month special for Trust and Will. There will also be a notice on our website as well for that special for April. And be sure you keep on a lookout for other things coming in April, since it is National Financial Literacy Month and National Credit Union Youth Month on there. Now, O'Neill and Jason, the other caveat to my question is we have members in 20 plus countries. So would the services provided through Trust and Will apply to them? And the reason I ask is I know you can't use one country's laws in a whole new country. That's not how it works. But being that this is more of a document outlining your wishes, how would that factor in?
I can answer part of that question, then maybe Jason can hop in as well. But what's included in the price of your estate plan is printing and shipping of the documents. The caveat to that would be that we only print and ship domestically, because it's a large expense on our end as well, to get those documents printed and shipped to you. So you will, if you live in the United States, receive a physical copy of your documents in the mail, as well as a digital copy, which you can share with your loved ones. And Jason can potentially chime in here and address the specifics about living foreign or outside of the country.
Yeah, to build on what O'Neill said, I mean, you can download and print your documents free of charge if someone's in, another country. One of the kickers maybe though is you would have to go to like a U.S. embassy or a U.S. consulate to be able to get them notarized. Because like if you were in Brazil, I was talking to a guy earlier today. He didn't live close to an embassy or anything, so he could only find a Brazilian notary. Therefore, his documents wouldn't be legal. And it's important to note that we can only account for assets that are held within the US. There are some countries, which I can't speak to, that do recognize, US based wills or trusts. But of course, those are going to vary from country to country. So.
Well, thank you both. I know that's probably a unique question among credit unions, but there are a good handful of us that do have members internationally, um, which I feel like I should have known that. But then once you start working in the credit union world, you tend to see things a little differently. Because I'm a legacy member. My parents both worked for EDS and signed me up when I was very young. All right. Looks like all the questions have been answered. Thank you, Jason, for answering those so quickly. O'Neill, thank you for presenting to us today. For all of our members here, thank you all for giving up your time to listen to us and join us for our webinar series today. Please continue to be on the lookout. We will have many more webinars, so watch your email, follow us on social media to see when the next events will be. The next upcoming one will be in later March on the 28th or the 29th, and then more will come later in the year. And then, of course, O'Neill, Jason, and Trust and Will are available 24/7 through our website, as well as we are available 24/7 through our website. But we hope you guys learned a lot. Please check out our preferred partner at Trust and Will to see what they can do to benefit you and enhance your financial well-being through your InTouch Credit Union membership. Thank you all so much.
Thank you.